be joined by Ruben Garcia Quismondo, who is the Managing Director of Cobala. I'd like to remind you all that we want this to be a really interactive session. So while Ruben is talking, or also at the end, if you have any questions at any point in time, please do feel very encouraged to just write them in. If you see at the bottom of your screen there in the toolbar, there's the Q&A feature. Please just feel free to just write a question there whenever you have it, and Ruben will stop and answer it. So without further ado, I'm now going to hand over to Ruben.
Okay, thank you very much, Hannah, for the introduction, and thank you very much for the Spanish Chamber of Commerce in UK for giving us again this opportunity to address all the attendants for this issue, which is a very updated issue because of the situation of the coronavirus outbreak in UK and all over the world, in Europe. And then I believe that this is a very helpful presentation for all the business, just to try to avoid crisis situation, and just to deal with this crisis situation that we must to deal as entrepreneurships, as businesses, because we are on a big threat in terms of health, but in terms of businesses, in business too. And then, as well as I told you, I believe that this is very helpful introduction and presentation we want to share with you. Of course, as Hannah told you, I will be more than pleasant to answer all your questions at any time. In case you have the chat tool so that you can write your questions, and I will answer the question at the end of the presentation. You must consider that nowadays, because of this virus outbreak in UK, it's really hard for everybody, and the most painful situation is the person who is in hospitals or even the deaths. Then we are really sorrow for all these people, but we must to address the situation that we need to deal. The first one is the health. Please stay in update with the health instruction of the government and try to continue improving the situation of the UK, because it's very important for all of us as a community, in each community around the country, but at the same time, and because we are in the Chamber of Commerce and we are going to address the business recovery situation. Cobala, as Hannah says, is an accounting and law firm. We have been in the business for almost 30 years, and we have been with our offices in London since 8 years now. I am insolvency practitioner in UK. That means that I am a licensed insolvency practitioner. In this business, you have to look for advice of accountants, tax advisors, solicitors, barristers, and insolvency practitioner. Of course, financial advisor, your banks, lenders, and everyone, because we must to try, all of us, to do our best to recover the business and try to avoid the close of the businesses, because it would be better for the society, better for the community, and for all of us. But of course, if you cannot avoid to close the business, please look for advice. There are many insolvency practitioners in London and all around the United Kingdom, England and Wales, and you can find highly skilled professionals who can advise you to take the property advice. We are going to go really fast because it's really difficult to explain you not all the tools that the government had put in place just because of the crisis, but the general regulation of the insolvency processes in the UK. As you can see now on the screen, you have two main issues, which is the businesses and the individuals, because we are sure that we are going to be dealing with hundreds of thousands of individual bankruptcies, individual voluntary arrangements, debt relief orders, because they are in horrible situation because of this crisis. But of course, at the same time, with the businesses, solvent and insolvent businesses, and at the same time, out of the code, the scheme of arrangement, creditor voluntary arrangement, other tools that UK rules, England and Wales, can offer you to try to avoid the situation and to, or even to improve the situation in case that you need this kind of. Who is an insolvency practitioner? In UK, there's a special regulation for the professional who act as insolvency practitioner. They can be appointed as liquidators, supervisors, trustees, depending on the case that you are dealing with. Then they are licensed professionals and they deal with this kind of processes, not just once you are insolvent or just because you want to liquidate the company in a solvent manner, or even before, just as advisors trying to help the manager, the directors of companies to deal with these kind of situations. Then licensed professional, they can add at that point in England and Wales as advisors and be appointed as liquidators, administrators, can act as supervisors, trustees, and so on. You can see now another one, which is the company voluntary arrangement and administration rescue processes. That means that this is the kind of process you would use in case that you want to recover your business, you want to continue trading, you are still looking for professional advice, and once you meet with them, you find out that there's still opportunities for the company trade and the company and the directors, even in case that we need some funds, they are there just to provide it funds or just to look for a kind of restructuring. But you want to continue trade, and even you do not want to lose the value of the company, even if you want to sell the company to third parties or even the directors, as we will see afterwards, you want to trade. Terminal processes, that means that you want to liquidate the company or you have to liquidate the company because there's no other chance for this business. It's just because it comes from the court's compulsory liquidation, which means that a court has appointed a receiver, which is an official servant, and this receiver will appoint an insolvency practitioner. Or even you cannot pay your due debts. That means that on the terms your debts are due, you cannot pay, you make your forecast, you make flows, you do whatever you have to do and the best you can do, but you cannot. And then you look for advice just to try to avoid the liquidation, but if there's no other possibility or the chance, then you go for as soon as possible, just to try to keep the value in the company, to realize the assets in the benefits of the creditors. Then that is the another process. And then you have at the end, the blue one, which is the member voluntary liquidation, which means that you want to liquidate, you want to end your business, but you have to pay all the debts, all the due debts. You are still in conditions to pay all your debt or your creditors. You want to pay them, and even you make a kind of declaration, a legal bind declaration that you are going to pay all your debts or your due debts in the next 12 months because you want just to close the business, but you have enough resources. I have to that a company voluntary arrangement, that means that you want to achieve a kind of settlement and agreement with your creditors to pay them, make maybe some cuts, you make maybe some delay on the payments terms so that you can keep trading and you can continue with the business. That means that you have to obtain the approval of the creditors of your company with a minimum amount of debt of 75%. Then that means that you look for advice, insolvency practitioners, solicitor, accountants. The accountant advise you to look for an insolvency practitioner this insolvency practitioner make a kind of advice and look at the numbers of the company and realize if this company can achieve this 75% of creditors, and then they can agree on these terms and pay the debts in the next 5 years, with even with a cut, just as a delay. That means that you pay all, but maybe the debts are less than it was before the creditor voluntary, but it needs the approval of your creditors. Administration, that's mean that you appoint an insolvency practitioner, and once this insolvency practitioner is appointed, this insolvency practitioner still look for trading of the company, even if the company will be sold on a pre-pack process. That's mean that maybe you have a business, but this business has still a potential life, a potential business life, and then you put it in a kind of package and you sell to third parts or even to the same directors. They were of the company, but you inform all the creditors. In case of these directors, you evaluate the company with a third part company specialized in valuation. You look for market your company, and once you have a transparent process, you sell the business, and then you obtain some kind of resources to pay the debts of the company, because after usually this pre-pack, the company goes into liquidation with the monies from the selling of the business to a third part or the director, and it's a better situation for the creditors that it was before. That means that you cannot say, okay, I'm going to go into administration, I apply for the insolvency practitioner to sell the company to the same directors they were before, and we are going to pay them less than if the company is liquidated. If I obtain in the company liquidation 3 and I obtain 4 for pre-pack, of course, it's better for the creditors, but it must be evaluated, it must be marketed to look for another, maybe better options to sell the company, and that is a kind of administration, okay? Then creditor voluntary liquidation. We enter right now into the liquidation process. This is a final process to close the company on time, and then we will look after that, because of government measure nowadays, even they have put in place some new regulation for the wrongful trading. That means that all the directors of companies that try to avoid to go into liquidation and to sustain the business, they must not be so worried as before because of wrongful trading. Once they are insolvent, they continue trading just to look for the survival of the company, surviving of the company. That means that you must not to be worried, but that not means that you can do whatever you want, and even you can take third part in good faith and just to increase your debts and not to try to sustain, to keep your business trading, and after to look for a kind of solution. Creditor voluntary liquidations means that the shareholders meetings and the director appoint an insolvency practitioner in an advisory phase, the phase 1, if you want. This insolvency practitioner advise you how to do the process. They call for the creditors meeting. This creditors meeting can appoint another insolvency practitioner, or just the insolvency practitioner stay on base, and they are going to realize the assets of the company in benefit of the creditors. And then once they realize the asset, they collect all the debts of the company, all the assets of the company, fixed assets or just book debts. Once they have collected all the monies of the company, they will pay the creditors. Unsecured creditors has their own secure assets for their debts, and secure and preference creditor will obtain this money, and the insolvency practitioner will pay them, taking into account the preference of the debts with the monies coming from the realization of the assets. Compulsory liquidation is a kind of liquidation. It's a court-oriented liquidation, ordered by court, It means that once a creditor has a debt and they look to obtain the payment to apply the company to pay the debts, but the company refused to enter into a kind of deal for payments or whatever, they go into court, they file for a petition of winding up of the company, and once the court give this information to the company directors, they do not attend or they cannot demonstrate that they can pay the debts, or they refuse to pay the debts, then at that point, courts can decide that the company must be into liquidation, appoint a receiver, which is an official servant, and this receiver will start with the liquidation process of the company, same than in credit or voluntary liquidation, realization of assets, collect debts, and then try to pay. Most of the cases, once the receiver has been appointed by the court, this receiver will appoint an insolvency practitioner to do the liquidation. But to be honest, there are some companies, they have no assets, they cannot pay even the expenses of the case, which is the insolvency practitioner fees, solicitor fees, barristers, accountants, tax advisor, valuation of the assets, and whatever, and then it must be carried out by a receiver because no potential assets. That's member voluntary liquidation. Is another kind of liquidation, but a solvent liquidation. As I told you before, at that case, the company can pay all the debts. The directors sign a letter telling, okay, I'm going to pay all the debts of the company, but I want to close the business because I want to take the company asset realization, pay the debts, and then we have to distribute these monies among the shareholders of the company. It's a very fast-track process, but of course, the insolvency practitioner will look at the state of affairs. You prepare, the director prepare with the help usually of the accountant, just to look and say, okay, there's enough assets for paying all the debts of the companies. Even we can pay all the expenses of solicitors, barristers, insolvency practitioner, public, whatever. And then once we have paid all the expenses, once we have paid all the debts, even we can pay some certain amount of money to the shareholders. It can happen. You do not want to continue keep trading, or even you have a kind of tenancy agreement and then it closes and you do not want to continue, but you pay all your creditors, and the insolvency practitioner will look at that and be sure that you are capable of paying all the payment. Scheme of arrangement. This is a kind of oriented process for usually financial restructuring of companies. That means that debts are usually enough amount of money, then you call the solicitor and the insolvency practitioner. They have at the core two kind of appointments. Once is just to establish the group of creditors, looking for a kind of relationship between these creditors as a family, bondholders, or whatever, the stakeholders of this process. It's regulated, take into account that this is not regulated in insolvency law, but in the Companies Act, and it's a kind of very flexible process to make a finance restructuring of the company, and it must be at the end approved by the court. That means that you have to attend twice the court with your barrister and solicitors and with your insolvency practitioner and financial advisors, because you have settled an agreement and a scheme of arrangement with your creditors. It's a very professional and very high-skilled professional join this kind of cases. That means that is usually, as I told you before, for medium to big size companies, group of companies, and even because the company has a kind of future once they have restructured the financial debts of the company. That means it's a kind of most of the settlements is done out of the court, but with the supervision of the court, because the court must approve this kind of processes. Informal insolvency arrangement. You can call your creditors, you can try to obtain a kind of settlement, a kind of agreement with your creditors to pay them just in different times or wherever, but you must take into account that this has lack of protection, is not legally binding, but you can do it legally binding. It depends on the agreement, the contract you sign with your creditors to remove your debts and to give them a new terms. But as far as it has no protection, you must to take care, you must be sure that your creditors are in a position to deal with you and not to go immediately to court and just to enforce their debts because they do not trust you are going. Then this kind of informal process, which is usually the first step, people, business directors and so on in small and medium-sized companies, you must to take care because maybe you are just wasting time and you can be in a position of being dequalified as director just because you are wasting time. At the end, you do not obtain the enough support of your creditor, your lack of protection, and some creditor even take the advantage of going into just filing court and that's all, no? And look for the enforcement of their debts. Take into account that because of the situation we are living is not a normal situation. I have not to insist on that. It's very easy, no? We are on a virus outbreak around the country. Many businesses are just closed. They have to close the business. They are in. They stay at home, and that means a huge crisis for many companies. And then the UK government and the courts and everyone is trying to help the business to keep on trading once the virus when we have control this pandemic, and then we must return to our works, to our business, and to try to keep trading and to try to keep the employees. Then the government takes some measure. It's a kind of labor measure, job retention schemes. It's a kind of tax measure, deferral of tax, BIT, pay a corporate tax, all the taxes. They have studied the situation. Her Majesty Revenue and Customs is trying to help the business to keep on trading. But of course, when you can keep on trading, you can just defer your debts, but you are going to attend the debts on a future, and then okay, because the situation is not a normal situation. Nobody is guilty for this situation. We as citizens, we have been suffering this situation, the business sames, and then I'm going to help you to keep your trading, to keep your business, to try to sustain the jobs of the people. And then they have approved labor, taxes, even some commercial rules just for shareholder meetings, annual accounts, and even they have some new measures for insolvency process. Most looking at the wrongful trading is like telling the business, the directors, okay, you can keep in trading. Try to do the best you can. Honestly, please, honestly, take in mind that to keep your business open, to recover your and to continue with the business. And then I am going to help you as far as I can. If you have to file for the annual accounts, no worry, just file. You cannot submit the annual accounts on time, and then the Companies House will give you 3 months more to submit the annual accounts. But you must to feel deferral of the annual account, so you will be surprised for a penalty of the Companies House. You cannot pay your BIT, or even if you look at your cash flows, you say, okay, if I pay now my BIT because I've been closed 2 months and I have no incomes, but I must to pay the rents, or I must to pay some employees, or I must to pay some debts, then that means that you must to try to defer the taxes, but taking into account, you have to put in place, figure out your numbers. This is the incomes I forecast for the next months. Imagine we are in June, July, August, September, whatever. This is my incomes, this is my expenses, the payment I have to do, and now I have to pay my taxes, my company insurance payments. Okay, I can defer that as far as my cash flows, my business plan tell me, okay, I'm going to be solvent. I will pay. I will pay. I will delay the payments. I will defer the payments, but I will pay because I expect to recover my business, my company, once I open again my business with healthy measures to be sure that all of us can keep safe in our return to the normal life. Then the government had put in place this kind of measures, and we have to keep mind, because I believe that this is a key question. If you want to sustain your business, we are going to go very, very fast. No, restructuring will be allowed. This is kind of wrongful trading. You must do in normal times, not in the coronavirus outbreak. You must to keep in mind that you cannot continue trading once you are insolvent. You know you are insolvent. You know you are going to be likely insolvent. Please go and look for advice, insolvency practitioner, and they will advise you, solicitor, accountant, whatever, the professional, the skilled professional, you need to do that. But, and because of the crisis of this virus, okay, we are not going to consider to disqualify directors just to try to keep the business ongoing. This is a kind of measure we have been Tuesday in Spain, exactly the same. We see the same in Germany, in France, in United States, in Italy, in every place of the world, governments are trying to send the message to directors and to businessmen. Please try to keep the business ongoing, try to keep the business trading, try to avoid the insolvency if you can, but please be serious. Take into account that if you take risks, it's not just because you are not an honest guy. No, you must to keep in mind that you have to do this business plan. You have to take your evidence that you are trying with the money you collect to pay your debts, to defer the taxes, but you believe that once you keep running your business, you will have to pay, you will pay all your debts in short terms, in August, September, October, November, even until March of 21, as we will see. Okay, then not be concerned and be concerned. If you believe that your company can continue trading, please do it. Try to do it. And look for the advantages the government have approved, because they will help you in terms of everything: annual accounts, shareholder meetings, delay of shareholder meetings, internet shareholder meetings. You can do it now with the new measures of the government. You can keep trading because you are not going to be disqualified because of wrongful trading, but take all the measures, as I told you before. Even you can put your employees, everybody has already heard about the job retention scheme the government has approved, just to say, companies, retain your people, your employees. These are the main assets of 99% of the company, your employees. But maybe because you are close, you cannot pay the salaries, you have no incomes, you cannot pay the expenses. It's not possible. Then you apply for this job retention scheme, taking into account that these employees must not work. They must not work. This is something I don't find very flexible in UK. In Spain, for instance, you 70%, 50%, these employees, this not. In UK, you can just apply for this employee 100% furlough, these employees continue working. Any case, you can do that, and you can apply Hermeister Revenue and Custom portal. They have built up a kind of portal in the Hermeister Revenue webpage, and you can apply for £2,500 maximum amount, or 80% of the salary of your employees, national insurance contribution, and even for the payments for retirements. Okay, then you can do it with your some employees, but because you have reason to do it, because you have been severely affected by COVID, who is not severely affected for this is the question. No, there are many legal questions we can answer, we cannot answer, and even, but I believe that the most important question, you keep all the information, you make evidence of your honest behavior, you are a good merchant, you just to try to keep your business on, then you look for the people, look for your own employees, and you put them on a job retention scheme. That means another point in favor of the UK regulation, and not in the Spanish case. The Spanish case say, if you put these people in a furlough, even you do it for 50%, you must compromise to keep the employees for the next 6 months when you finalize this term of the furlough of the employees. In case of UK, to be honest, I agree with the government. There are companies, they cannot sustain all the employees. They have 10 employees and they say, after I need just 7, that's all, and then I must lay off some employees, because I have to try to make my business, to keep my business trading, and to survive in this very horrible situation. Because you must keep in mind that this situation is not going to be just once we come back to our offices, our jobs, our normal lives. We have no vaccine. That means that we be on that circumstances maybe until March 2021. I hope September, but this is not a real expectation. You must to keep in mind that maybe you have to keep in mind that you are going to be on this kind of situation until May 2021, once the UK government can provide all the UK citizens with a vaccine. And then it is something that you must to deal with them, and you must to take into account into your forecast, into your business plan, no? Because if you have a path, you cannot think that all the people will come back and we are going to be 100 people in a 2,000 square feet path. Not possible. There's no enough distance. There's no 2 meters. Even if you go with the face mask or wherever, you must to have some hygienic measures in your path. Then take into account this situation, and the government has provided, has approved for all of us. I think that this is a very interesting, but do not forget, I must advise you, I must to keep in mind, fraudulent trading still exists. Wrongful trading not. Fraudulent trading, yes. I know I'm not going to be capable of sustaining my business. I continue trading. I create more debts than normal. I do not care about the evidence. I didn't do any business plan, I didn't look for any advice. I didn't look for solicitor, accountants, that advisor or whatever. And I kept trading. And once 6 months after, I said, okay, I was insolvent in March, because the wrongful trading back to March the 1st. And I continue doing a kind of mountain of debts of fair, good faith creditors, and just to say, okay, I don't pay you. Now I go to visit an insolvency practitioner. I want to say, okay, I didn't pay because I didn't want. No, that's not possible. That's not possible. That not means that. And even Mr. Sharma had said that, okay, we help you, honest merchant, to fight for your business, to try to keep the situation. the livelihood of people. Yes, business, employees, all the citizens. But at the same time, be honest, be serious, look for the advice, and try to recover your life as soon as possible. And once the government allow you, of course, this is something that you must keep in mind. Okay, I'm not going to go into another question is that everyone who wants afterwards the presentation, do not worry, we will send you the presentation because it's not, we are not going to go into the details, and you can find there even the ads or the rules you must look for once you want to look for the taxes, for the job retention scheme, for the delay of filing for annual accounts, for the delay of shareholder agreements, all of things, even if you have some question in your mind related with the wrongful trading new regulation, these 3 months back to March the 1st, you can keep trading once you recover your life. No problem at all. We will send you all the presentation, and you can even, the details of us, you can contact with us or contact with any professional, please. It's very important to look for advice at these horrible times. We must to deal with them, okay? This is very, very important. There's some new measures. They have not yet approved, but they are starting to approve, which is going to help business to try to obtain settlements, such a kind of a scheme of arrangement for small and medium companies to keep some CVAs with moratorium extension so that you try to settle with your creditors the position. But there are some very complex rules, absolute priority rule, best interest test, and this kind of reason because I told you for advice because I cannot explain you which is the best interest test, which is the absolute priority rule, which is the same time is the similar to the European Union directive insolvency. It's not exactly the same, but it's in, for instance, in Spain, we have already tools. Our moratorium is for, as I told in Tuesday, 4 months, 3 months plus 1 month. You can do it out of the code. You can stop the enforcement, not just the public enforcement. But in UK, want to improve the regulation just to try to avoid the thousands of liquidations, administration, and hundreds of thousands of individual bankrupts, IVAs, and so on. BIT, you can defer the BIT for the period of 20 March to 30 June. If you cannot pay, if in your forecast with the evidence, you say, okay, I cannot pay, I cannot pay. I was open until 15 March. Now I must do, I close, I've been closed for 2 months. It's too much. I need to pay other things, raw materials, I need to pay the rents, whatever. Okay, no problem. Even you do not need to apply. You can do that, but keep in mind, please, you must to pay afterwards. And even if you have the money to pay, not just question, I have £100,000 in my bank account, I must to pay 20 and I want to defer the payments of taxes. This is not the point. You must to pay your taxes. It's a duty. It's a common sense duty we need now because the government need the resources to help the people, the business, to keep their livelihoods, to keep their normal lives. But if you need, don't worry, do it. You have the measure in place and you can even defer the payment of the BIT March the 20, June the 30 until March 2021. And you do not need to apply HMRC and say, no, okay, I will do. And it's almost the same for pay, not exactly the same. You must to pay if you can pay for corporate tax and everything, even if you have in place a kind of TTP, which is a payment, deferral payment you have already settled with HMRC, but you cannot attend this payment on term, and you know now because of this crisis, then you can defer the payment of this TTP, or even you can try to keep in contact with your supervisor, with your insolvency practitioner acting as supervisor, or even if you have no supervisor, it was just a free TTP with HMRC, call them, no personal attendance, and HMRC is for healthy reasons, is common sense too, but you can try to call them. To be honest, it's really difficult. Nowadays, many people is calling and they do their best, but it's not possible to attend all the people. But yes, you cannot pay the TTP because the terms, it was, I thought these payments 2 years ago and now I cannot. No problem. Do it again. You can do it. Honestly, you can do it. And based on case by case, HMRC has adopted a flexible position. We will try to help the honest businessmen to keep their business, to trade, to keep their employees, everything we can do for business, for people, but at the same time, I need, as HMRC, to know your situation, your business, your expectation, forecast, everything, or even your accountant, your tax advisor, or your insolvency practitioner. Job rotation schemes, I told you, is just for 3 months, the initial period, allow the company to apply HMRC for the employees and the national contribution, no? Then it's really a good tool you can use in case that you need to use that because you close the business and you cannot work at home. You cannot stay at home and work because I have a pub. I'm a kind of merchant in the high street, and I have a shop, and then there's no any possibilities. I cannot even deliver at home my food or whatever. Then, or I can deliver, but just 20% of the usual business I had. Okay, then I keep one, but the other 3 employees go into job retention scheme because they are not going to work for the next 3 months. As far as I have to close my restaurant or whatever, no? For company's house annual accounts, you must apply, you must fill for this extension for 3 months, but you can do it, but do it please on terms, and the terms is already over, but and then in case that you didn't do it, maybe you will be penalty. But if you are even under stress because you were infected by COVID, no problem, apply. Company's house will take care into consideration your personal situation as director. I didn't submit my annual accounts because I was infected, and then I couldn't. No problem, of course. It's common sense. Again, we cannot keep on our duties sometimes. If you, some final thoughts, because I think that I have to stop and to give you the chance to answer your questions. If you have final demands for payments of your creditors, insufficient funds to pay bank, HMRC or trade creditors, county court judgment or decree against the business, can't draw any money from the business, you cannot, and you must live for something. Director needs to use credit cards to pay business debts, business account overdraft limit. You have a limit of overdraft, you go over. Business borrowing increase just to keep company running. That's means that you have not enough incomes to pay your current debts, and then the debts grows and grows, and then you look for finance just to keep your business open, but your debts are increasing, and then you try look for advice, speak with your accountant, speak with your tax advisor, speak with an insolvency practitioner, solicitor, professional, skilled professional, licensed professional. In UK, you can find many of them in London, of course, and everywhere, and try to be advised. So we are more than delighted to help you. We do not charge you just for asking. We have done a pro bono policy times for employees, people who cannot pay us our usual fees, no problem. We help the people. We are part of the community and we want to help the people to sustain their livelihoods. But if you are a business and you ask some questions just to understand the situation and the tools you have, we are not going to charge you. Most of the professionals in UK are not charging right now just for, and it's like always, we have not charged you for the first questions meeting or wherever, but even now we are more flexible. We have a very approach, it can be a commercial approach, but at the same time, a community approach to the people. We have answered many questions of employees and we didn't ask for our fee. We understand that we are part of the community and we have to be in the good times and in the bad times. And then thank you very much for attending this webinar. Any questions? I look for them. I have some questions here. The IP can request the declaration of guilt of the administrator of a company and hold is responsible for all of the company as it happens in Spanish law. Yes, it's different process. In Spain, you look for the sección sexta de calificación. It's a kind of disqualification process. In the UK, we must to submit in case of insolvent liquidations, we must to send the report of a kind of investigation about the director's status, the full file of director's status and the debts and so on. We cannot share this report, this research, this investigation with the director of the company once we have been appointed as insolvency practitioner, and then we submit to the insolvency service, and the insolvency service will study it, and in case that they find guilty the director because of wrongful trading, think that the 3 months, but there's still wrongful trading after this term, or just fraudulent trading, realization of assets, undervaluation of with preference to some connected parts. Yes, yes, we do that in insolvency process. Yes, yes. Can an IP refuse to accept the case? Yes, yes. In fact, we refuse many cases because if a case is not, we must study our data. It's a IP data. I have to study the case. If you come to our company in London, in the city of London, where we are in Queen Street. Okay, nice to meet you, nice to meet you. We meet in the normal times. Now you call me, or even we have a internet connection, and we are still for you, of course. I'm still for all the companies asking us. Yes, you explain me your situation. You provide me state of affairs, balance sheet, profit and loss account, number of employees, rents, assets, wherever is your company and all the company. And then I study that, and I have to study the expenses of the case, IP, solicitor, barrister, company's house, a London Gazette. I need to take into account the valuation fees, even I have to look for a third company to market your company into the market. Then I make a kind of case budget, case profit and loss. And if I am sure I cannot pay all the fees, I need to carry on with my duties properly, because I'm subject to huge regulation inspections of all the cases I manage, then I will refuse you. I will not refuse you because maybe my fees are X and you cannot pay me more than 80% of the, because you do not pay me. I take the money from the realization of the assets. Then I will make a kind of account of the case. And if I am not sure I can pay all the professional around the case, maybe I will refuse you, of course. Or even you ask me, oh, Ruben, I want to go into administration, but you are not trading. You are not capable of paying your debts. You have no chance to achieve a kind of greater voluntary arrangement. I will refuse, of course. I will tell you, no, you must go into liquidation because you are not, in fact, you are insolvent. You cannot continue trading. You cannot continue increasing your debts because these go against the third part, good faith third parts dealing with you. Then I will tell you, okay, I accept the case. As far as you go into liquidation, this is my advice. You must go into liquidation. You must go for a CVL. The assets are enough to pay the expenses and to pay even some part of the creditors, because I have to take into account the creditor rights. There are unsecured creditors there, and maybe we cannot pay them because there's no enough money. But yes, I can refuse. In UK, IPs must not to accept cases, insolvency cases. We cannot. There's official receivers for that. Ask your creditors, call them, look for a solicitor, and try to get them. But I cannot accept a case with enough resources to pay all the expenses, all the case, or at least just with a forecast, because of course I have not a crystal ball. I cannot forecast the future, but based on my experience, and I have more than 20 years, I will look at the case. I will take maybe 1-2 days with the balance sheets and take into account I'm an accountant. We have solicitors in the company, abogados. We have all the skills people we need to take a look at the case in some hours, in some days maybe, and say, okay, this is the strategy for you. And if you accept this strategy, yes. If you do not accept, no. If you want to go, and of course there are other reasons, anti-money laundering, reason I can refuse you, of course. There are many reasons I can refuse you because anti-money laundering or criminal activities, of course, I will refuse you. I will not be engaged on a criminal business, of course, just to liquidate, of course, no. And then, yes, we can, for many reasons, and we are not obliged, we must not accept all the cases for many reasons, as I told you. The internal revenue has some privilege. Internal revenue has some privilege with respect to the rest of the creditor. I don't understand the internal revenue and what it means, but if you are speaking about the expenses of the case, the fees of the professional, the first, we are the first, of course. We are a business. We cannot manage a case if we do not earn money, because then we cannot run our business. It's the same than a pub. If you ask for a beer, they will charge you the beer. If you ask for a burger, they will charge you the burger. We charge our fees. We can deal our fees. We can accept some flexibility because of the assets. I will not collect no money. Of course. But this, I told you in the before questions, I must to keep the business running, to be profitable, because we are independent, transparent, subject to regulation, subject to our professional body, and to keep independence, to keep transparency, to keep a good professional everyday study, you need to earn money. And if I'm going to use a solicitor, of course, do you think that the solicitor is going to have a case just based on, oh, Ruben, I'm your friend? No, they can tell you, okay, I get the case on a success fee, of course, but they have to study the case. And I have enough experience to say, okay, there's no, or even there are debt collectors companies, and then I do not care about the debt collection, and then they will give us 80% and they get 20, 50% of the debt collection. Yes, there are many ways to realize assets, but yes, we must do studies completely different than in Spain. Take into account that not in Spain, in France, Portugal, Italy, Spain, Germany. I've been doing this kind of course in Germany and in Italy. I attend all the European, worldwide, Ibero-American, and so on. That means that I'm a worldwide experienced insolvency practitioner, restructuring, and doing this kind of business, another business. And in Europe continent, the process is much more code-oriented process. In Germany, the insolvency practitioner are going to be appointed by the code. Then the creditor meetings, and the creditor meeting can change that. In Spain, in France they have two kind of bodies, which is one of them is conciliateur, and the other one is the liquidateur, and then they have to take into account, they will try to obtain, then it's different in UK, in common law, because when you speak about UK, you are speaking about Australia, New Zealand, Hong Kong. We have office in Hong Kong. It's almost same regulation. All the old colonies at UK around the world has not exactly the same, but it's common law. Almost 25% of the worldwide population has this rule, and the other one, 70% has the European continental in Ibero-America from Spain. In US, take into account, it's not common law, please. US is a different country. It's not Australia, Canada, wherever. They have states with common law, states coming from Spain, which is 70% of their territory, and many other questions. You cannot consider US a pure common law system. I heard Hermeister Revenue and Custom are recovering the status. Yes, they are recovering the status as preferential creditors. They are on the way. I'm not sure they will not stop that, but yes, they want to recover the preferential status they had before. It's a back step, in my opinion, in the opinion of R3 or IP professional bodies. We believe that this is a back step. We go not forward, but back, but government is government. And if the government approve a law, we must to file the law. No other question, but yes, it's true. I believe I have already answered all your questions, and I've been speaking to you 1 hour, almost 1 hour. Then if you have another question, please do it right now. If you have not another question, I will thanks. There's another question. Thank you very much for all your questions. I am more than delighted to answer you the question, and I will try to do it very fast. How long can it take for a shareholder to get his investment bank in MBL? It depends. I cannot answer you. You have some bonds, and the maturity is in 6 months. I can realize these bonds, but maybe you want to wait. No, MBL takes 6 months. The problem nowadays for MBLs we are finding is that the Hermeister Revenue and Custom takes longer time than expect, because they are sub-staffed. They have not enough resources. And then we must to ask them for a clearance letter telling us that there's no any debt with them, and then it takes more time. But investment banking and MBL, it depends on it case by case situation. But usually MBL can take 6 months, 8 months, 3 months. It depends, and you have all the liquidity in a bank account, and then of course I collect all the money, I pay all the debts, I ask the Hermeister Revenue and Custom for the clearance, and they answer me in 2 weeks, not in 3 months, 4 months, some months. I don't want to criticize nobody. Everybody do their best in UK, in Spain, everywhere. I'm very positive, even that we are surrounded of this negative environment, but it takes time. Sometimes it takes longer than we expect, and it takes longer than we desire. And yes, I think that this is Last question. I hope I have already answered all your question. I must to help to say you thank you for joining us today morning. We are here to help you. If you do not like Quabala, look for another professional. There are Spanish chamber members, there are solicitors, they're good professional. You can look there, you can look everywhere, but please, please look for advice, stay at home and keep safe. And thank you very much again, Spanish Chamber of Commerce in UK for giving us the chance to address you today morning.
Brilliant.
Bye.
Thank you so much, Ruben. That was really interesting. And thank you for answering all the questions too. And thank you also everyone who's tuned in to join us this morning. Please do keep an eye on our website in the events section, where we've got lots more webinars coming up over the coming weeks, and just register for any that take your interest. And yes, do get in touch with Ruben if you'd like to know more about the services of Quabala. Okay, have a nice bank holiday weekend, everyone. Bye-bye. Thanks,
Bye,
Ruben.
bye. Bye, bye, Hannah. See you.